Well, recent court opinions highlight just how unique tax law can be when it comes to how farms operate. Roger McEowen with the Washburn School of Law out of Kansas joins us now with a further look at the situations. Roger, as always, thanks for taking the time to chat with us. Now, the first case you wanted to address involves an Iowa farmer deducting old tractors. Give us a recap of that, if you would.
Well, this is an interesting case, Janet. This happened just a couple of weeks ago. The opinion came down out of the tax court. It was an opinion by Judge Paris. And I'd never seen an argument like this before. This was a farmer that started farming back in the 1970s and had acquired, over the years, 5 different tracts of land, totaling about 500 acres. But he always farmed with old tractors. When he first started out, they were vintage 1940s and 1950s. He did have a full-time job as a UPS driver, and he would farm early in the mornings. He would farm after his shift until up about midnight every night, and he did that decade after decade. He kept acquiring land, kept acquiring the tractors, gets audited, and the IRS revenue agent denied his depreciation expenses, his fuel, his gas, his diesel, all of these expenses, and said, well, you're not a farmer. You're an antique collector because you got 40 of these used tractors that you had parked at your various farms. And he said, look, I do that to avoid debt. I do that because I can fix them. I don't have to hire somebody to repair them. And this is my method of farming. And Judge Paris said, you're entitled to whatever method of farming works for you. And he had a long track record of this working for him. So it was a bizarre case. It just shows you the length at which some auditors may assert various positions.
Now, the next case involves commercial wind energy projects in Oklahoma. What are the highlights there?
Well, this was a tax case, and the county assessors in Oklahoma had valued certain projects at $458 million, and the wind energy company asserted that the projects were only worth $169 million for ad valorem real property tax purposes in Oklahoma. And so you can see right away, if you didn't have the wind energy production tax credit, you wouldn't have these, because that's the bulk of the value in these. And so under federal law, with that production tax credit, if you don't have enough tax liability to use the credit, you can basically sell it to an investor. And so they are valuable. And that's why the assessors were counting those basically as property, as taxable property. Well, the law had changed in Oklahoma, and the appellate court came in here and determined that the change in the law meant that this type of intangible property is not subject to property tax. But I would caution that this result has been tried in other states across the country with mixed results. This is very unique to Oklahoma law. Other states have different statutory provisions. They have different constitutional provisions that define income that's subject to property tax in those respective states. So whether that production tax credit is subject to property tax is unique to a particular state's law.
All right, Roger, as always, thank you very much for your insight today. We appreciate it. Roger McEowen, he's with the Washburn School of Law, connecting with us today out of Kansas. Go online to washburnlaw.edu for more information.